Hello everyone, this is Bhargav Bhamidipati and I'm a student of law at ILS Law College. I'd like to commend the initiative of Jagriti by the Statesmanship Programme and thank them for inviting me to speak on this particular panel. I'd be talking on the socio-legal problems that arise in front of the country in times of this COVID-19 pandemic. I would address three particular issues during my address. The first one being the legal incapacities that India has, especially to address such a large scale pandemic. The second one would be on the role of social mindset of corporations and small businesses uh, in maintaining the financial stability of the country after the pandemic. And lastly, I would address the misinformation which is around during these times of pandemic and the legal instruments that we have in order to tackle it. Addressing on the first question, which is on the incapacities we face in order to tackle the pandemic, it is pertinent to note that in India, the public health as a policy is completely under the state list, which is the states are exclusively empowered to legislate on the particular issue. This is because under the 77th schedule of the constitution, there are three lists. The first is the union list, on which the central government may exclusively legislate. The second is the state list, on which the state governments may exclusively legislate. And third is the concurrent list on which both the governments may legislate, but in times of inconsistency, the central legislation may prevail. So, because public health falls directly in the domain of state list, the central government is in a way incapacitated to address the particular issue. And I think another significant role which incapacitates the central government to address this problem is the 123-year-old legislation which governs the pandemic, which is the Epidemic Diseases Act of 1897. The Section 2 of the Epidemic Diseases Act empowers the state to make measures in order to prevent the spread of the disease or segregating patients, etc., which essentially means that these measures are to be taken by the state government and not the center. In this particular situation, when the only legislation governing the matter empowers only the state, and secondly, the matter also falls under the state list, the central government is absolutely incapacitated to address the particular issue in a very better way because we essentially need an overarching power with the central government in order to allow them to make policies and make give directions to states in order to take measures throughout the country. And this is particularly becoming difficult because of this legislation. Even the health secretary to the Union Health Ministry, Rajiv Gauba, has advised states to use Section 2 in order to implement the guidelines by the Union Health Ministry. Which means if the state government does not want or does not wish to implement certain measures by the central government, it is completely justified or legally justified to do so. I think this particularly has created a lot of problems, and I think the legislation, which is the Epidemic Diseases Act, is further far more old or to address the particular problem because Epidemic Diseases Act was made in 1897 when there was a plague that hit Pune and Mumbai, and it does not have the comprehensive details or comprehensive mechanisms in order to address a particular legislation. Two important initiatives had been made by the governments of India to change the scenario and bring in a new legislation. I think the first was made in by the UPA government in order to bring the Public Health Emergencies Bill because the states felt that it was infringing on their right because this matter is particularly under the state list. And the government then was a minority government. This bill could not be passed and went into the back. Even in 2017, the present government had brought a legislation, which is the Public Health Act, which essentially deals with all matters regarding epidemics, bioterrorism, and other health emergencies. It has a comprehensive mechanism in order to address the particular issue where central governments may be incapacitated, and thus, in times of emergencies, it may usurp the powers of the states to direct them in order to take measures during these times. But again, this bill is still not a legislation and has not been passed by the parliament. Then this brings us to the next question: when such a time of incapacity, what is the course ahead, and how would we address it? I think there is multiple provisions under different legislations which are being used parallelly. One is the Disaster Management Act, because the central government notified this COVID-19 pandemic as a notified disaster. Now, the Disaster Management Act is also at the helm to assist the governments in their work in preventing the spread. I think then there is the provision of 144, which helps the governments, which gives the powers to divisional magistrate or district magistrates to restrict movement of people. I think there is an advocate on the panel as well who would be in detail, who would address this such question of what legal framework is there at this point in a very detailed manner. But the question here essentially is that what the governments may do in order to facilitate or provide more power to the central government. This can be achieved by a financial emergency. A financial emergency is a provision under Article 360 of the Constitution, which provides the central government to direct the state governments to take certain measures as prescribed or as specified by the president. This particular measure might be important if the pandemic is on the rise and more emergency like situation arises. An important fact of in this particular matter would be that if this was a situation before the 44th Amendment to the Constitution, even the emergency, which is the general emergency throughout the country, the provisions of it could be applied. But the same did not happen because after the 44th Amendment, the term under Article 360 was changed from internal disturbance to an armed rebellion. So obviously we cannot categorize a pandemic as an armed rebellion, but provided it was a pre-44th Amendment period, we could have characterized a pandemic as an internal disturbance to allow and give way to the emergencies. In an emergency, the state may make any policy or decision on all the three lists, which is the union, state, and concurrent list. This would allow the government to better address pandemic throughout the country. Another way could be by implementing an ordinance which allows or gives way to the Public Health Bill of 2017, which is pending, and allows it to come into fruition for a limited period of time in order to help or give powers to the central government to make necessary directions during this particular pandemic. I think these are the only ways, or these ways would be the most optimum ways by which the central government may make a provisional way or find a provisional way in order to address this particular problem where the central government is completely incapacitated in order to address directly the particular problems that arise under this pandemic. So I'd like to talk about how social approach or the social mindset of businesses and corporations towards their contractual obligations would decide to what extent we can achieve financial stability after the pandemic is over. Uh, a few important things before we discuss. We need to know that 30% of India's market economy was wiped out in the last few weeks. This has particularly resulted in large supply chain disruptions in the economy, which means that performance of contractual obligations is either interrupted, delayed, or cancelled by parties like businesses and corporations. This has further resulted in counterparties also seeking to avoid their contractual obligations. Counterparties are essentially, for example, if I am buying something from A and processing it and selling it to B, if A takes an exception and says that I would not be able to perform under the contract, I am also seeking to not perform towards my contractual obligations towards B. All these exceptions or all these non-performance of contractual obligations essentially arise out of one exception provided under the Indian Contract Act, which is the provision of force majeure. Force majeure is embodied in section 32 and 56 of the Indian Contract Act. It primarily includes acts of God like natural disasters, wars, or warlike situations, or epidemics in general. The expert opinion in this particular context has been that provided all these exceptions of force majeure are used only when they are very necessary and all the essential requirements of the exceptions are duly fulfilled, all the obligations put by the exceptions are also fulfilled, then the amount and extent of financial instability that may occur after the pandemic is over could be limited to a greater extent. In this context, we shall look into the requirements or the general requirements, especially in the context of the pandemic. Justice Rohinton Nariman, in his decision in Energy Watchdog versus CERC, which was a 2017 decision, has largely set out and summarized the provision of force majeure. The few requirements which we need to discuss would be the first one would be the requirement of notification. It is reasonable to expect that provided a party is going to opt for the exception of force majeure, they should by this time notify the other parties that they are seeking to take this particular exception. This requirement is largely construed as a very strict requirement of notification. Other requirement under the provision of force majeure would be, say, the duty to mitigate or show reasonable diligence. This duty essentially entails parties to take necessary precautions, and if there are any ways in which the losses could be avoided, they are obligated to take those particular measures. For example, if I'm selling something which is perishable, for example, some fruit, and now that there's a national lockdown, I cannot sell it to the usual buyer in this particular and cannot perform under that contract, then I should usually, if I have time, keep those particular perishable fruits in a protected environment, and if that particular measure is possible to do. If I don't do that, and if I face losses, I cannot claim that my non-performance of contractual obligation was due to a force majeure because I essentially did not fulfill the duty to mitigate or did not take reasonable diligence. These two are primarily one of the most important requirements. One other requirement in the present situation which would be relevant uh, is the unforeseeability of the act of God. The requirement essentially is that particular act of God should be absolutely unforeseeable. This requirement is a very interesting one in the present context because the COVID-19 pandemic reached India far later compared to the other countries. Even the first 100 cases were arose in a very longer stretch of period, which means there was reasonable time for parties to know that there is a foreseeable chance that there will be a pandemic. But it is also to be noted that a sudden strict measures were implemented by the government in terms of national lockdown and other measures, amongst other measures, in order to prevent the spread of disease, which means the act of God essentially resulted in further measures, which also then made it impossible to perform under different contractual obligations. So, the context and to the extent this requirement of unforeseeability is a very vague one in this context and would be needed to be interpreted by the courts. Other than this, It is important to note that these provisions of force majeure also form a part of the international commercial contracts. For example, the Article 7.1.7 under the Unidetroit principles also encompasses the principle of force majeure. It is also to be noted that in public international law, under Article 23 of the Articles of State Responsibility, force majeure is an exception to treaty obligations for states. But multiple decisions were taken during the Argentinian economic crisis, where it was held that because the economic crisis arose because the state could not take measures to stop it or make the situation better, and thus the state cannot take the exception of force majeure. Similar observations can be made in the present situations in multiple countries, where it can be held that the state did not take necessary measures far early, and thus now cannot claim an exception under force majeure. Thus, claim of a successful claim of force majeure seems far difficult in the context of a public international law matter, but is a very plausible one in the context of private international law, international commercial contracts, and definitely the domestic context. Thus, the court opinion still remains that provided we take these exceptions only when they are necessary, and then we fulfill the requirements under the exception, we would be able to successfully mitigate the financial losses which we would incur after the particular pandemic is over.